see if we've got, make sure this is working properly, because right now I don't see the live stream going anyplace. It should come up shortly. So let's see if anybody is out there. Ah, I see we have a person, Donna Clark, is out there. Donna, welcome. Thank you for joining us. And I'm not seeing my live stream on my actual computer. June 12th live stream. Okay, there we go. I do see myself. Okay, so I see a couple people on there, so this seems to be working. I see we have a, and let's go ahead and reduce the sound over here. Welcome, thank you. And tell me, everybody, if my voice and my mouth are out of sync. Every time I have to do it, every time we do this, I have to make sure this is working right. So please tell me if you're seeing my voice and my mouth in the same plane here. Hold on one second, I'm sending an email very quickly. Okay, all right, so today we're doing, there we go. Okay, so we have a couple people here. We're doing something a little bit differently. I've got a friend of mine on the live stream. Her name is Stephanie Joy. Stephanie is a Social Security attorney, and she actually hosts a LinkedIn group where attorneys talk about different issues that we're all facing. So I'm going to see if I can bring her in to this, and we will find out what happens here. So let's see what happens here. Okay, see, there we go. There's Stephanie. So Stephanie, how are you doing today? Okay, I'm not hearing Stephanie. Okay, let's try to get this. I'm working on it, people. Okay, he says Isaiah says I sound pretty good. Okay, so let's see. There we go. Okay, we should hear you now, Stephanie. How are you doing today?
Hello.
Oh.
I'm good, but I can't see you. Is that a problem?
No, I just sent you a link to the live stream. So if you will, and let me see if I can do this on a split view where we can see each other here. No, we cannot. So let's.
I see the split, Jonathan, but it's just my side is black.
Okay. All right. Well, let's try it this way.
Should I be?
Okay, let's try it like that and see if it is working better now. Okay, that should work. So if you look on the actual live stream, you will see both of us in the split screen. So I hope everybody is being a little patient. This is a new technology we're working with, and hopefully this will work. Okay. So let's just do this. We're going to go into some of the questions. And basically, the way these work is we will answer questions from people. Stephanie, can you see the feed of people asking questions based on the link I just sent you?
I cannot. I can only see a white page with my face.
Okay.
It's not fun to look at. Should I be going to...
Go to the actual
YouTube
live stream,
or...
the link I sent you. It says youtube.com/watch.
Okay.
It's an email I just sent you.
So a new, the most recent.
Open up. Yeah, just open it up.
I see it. Okay.
Okay. Very good.
So
okay,
this is
so
going
let's
to put
just
me
kind
up
of,
in...
Yeah. Well, you know what? I think that we should hopefully have. Let's try this again. And let us see if this works. Okay, we should have a split view. And there we go. Okay, now I think I got it working here. Okay, so let's go ahead and get to some of the questions we're getting. We've got a bunch of people saying hello. We have Adam is asking a question. How long do I wait for SSDI back pay? I got approved in April of 2023. So my response to that would be that is way too long. If you got approved in April 23 and you have not received your back pay, then I think that, there we go, I see the switch.
Oh, I see you now,
okay,
Jonathan.
there we go. Okay, so somebody has gotten approved over a year ago, they've not received their back pay, that is an issue. And to me, what I would say that they should do is if they have an attorney, they should have their attorney contact Social Security to find out where their money is. If that does not work, if they don't have an attorney, reach out to their elected representative, their U.S. senator, their representative, and have that person find out, have the representative find out where the money is. I think April of 2023 is way, way too long. Okay. Good evening from Chicago. I'm in sync. It is in sync. We're both in sync. That's great. Okay. All right. Ginger says, I have my congressman involved now. My initial case has been pending since March of 2023. Thanks for the advice. You are very, very welcome. Okay. Let's go to some. Okay. Zippy says, I am on SSDI for 2 years. I received a BK 820 form wanting to know about work before I received SSDI. What would happen if I went over SGA before I was approved for SSDI? So Stephanie, why don't you take that one? You have a person who's approved. Now they're getting a question from Social Security asking about work they did before they actually were approved. What would you tell that person?
Okay, Jonathan, I got to tell you, it's a little choppy, and
okay.
I'm hearing two things.
Turn your can you turn your sound down on your computer? Now they're getting Social Security asking about.
I got double talk.
Yeah, yeah.
Okay.
Let's just go to you specifically. How about that?
I think I need to get out.
Yeah, go ahead. Go out and come back in. That'd be fine.
I'm wondering if I should just. I'm going to close out of the link I just went into.
Yep.
Which means.
And just re-click it and see what happens.
And you can hear me now, right?
I can hear you perfectly fine now. There's nothing. There's no feedback or anything like that. I wonder if you had it open.
Okay.
Twice.
So when I'm in that different software you have, where you don't see the chat room.
Yep.
That's where I went back to the YOLO Live.
Okay. Well, if you go to the actual YouTube channel and look at the actual stream as it's being streamed, you should see the chat room.
I know, but then I was hearing.
Okay. Well, mute your computer. Yeah.
Mute the YOLO Live or the YouTube.
One of the two.
Do you know what I mean? All right, I'm going to mute the YOLO.
No, that's not good because now I can't hear you at all. Can't hear you. Okay.
Now you can hear me.
Now I can hear you. Okay.
Okay. So it's just, I'm not sure what to do about.
Okay, well, you know what, I'll tell you, I've got you on the screen, so I'm going to ask you the question that's been asked, and just go ahead and, I guess, answer it. A person has been on SSDI for 2 years. They received a form asking about work done before they received SSDI. And the question is, what happens if this person was working over SGA before they were approved for SSDI? That is the question.
Yeah, so they're probably trying to find out what trial work period months passed, because they can occur before you start getting your payments, before you win your case, I should say, after your date of application. You agree, Jonathan?
Yes, right. And I think what we're getting at is that a person can apply for benefits, they can get approved, and but they may have been working over SGA, but they're still disabled. And so what Social Security can do is they can say, we're going to look at your work, we're going to classify it as trial work period, even though you have not yet been deemed disabled. And so it's just a way for judges to help people who are working even though they're disabled, but they still have significant medical issues. So yes, I think that's what's going on. But I think something else that's going on here is you have a person who maybe the earnings were not reported to Social Security, and so now they have been reported, and so Social Security sees earnings over SGA or substantial gainful activity before the person was approved, and that might lead Social Security to revisit the case and determine that in fact the person's onset date was later than they said, or they may have been overpay status. So that could be a potential problem. I think what I would do is I would create a spreadsheet of all the earnings you've had from the date Social Security is asking you on this new form through the present, and see whether or not you have gone over SGA more than 11 months really since that date. And if you have, you could potentially have an issue. If you had an attorney representing you, then you need to talk to your attorney about that. That potentially could be a big problem. That's my take on it.
One extra point, can I put it in there, Jonathan?
Yeah, sure.
I want to make sure I'm not overlapping. Okay, if you know, getting into your trial work period and then slipping out of your trial work period is not really troublesome to you, because you plan on keep working, you know you're medically disabled, but you're always going to be under SGA. It's not really the end of the world. Now it's if you're starting to go over SGA and you're not sure if that occurred if you closed out your trial work period, in other words, 9 months of the TWP before you even won, or shortly thereafter. If you didn't pop out of your TWP, you might have used some of it, but not all of it. Now you pay attention. If you don't care about getting out of your TWP, and some people don't, as long as they don't go over SGA, because once you're out of your TWP period and you bump into SGA, you're going to start owing every month had SGA income after your trial work period was over. You're going to owe those back. So you definitely want to keep track of it. But if the TWP isn't important because you know you're always going to be under SGA, it's not as bad as it might seem. But you do have to keep track to make sure you know.
So the point, I think one of the points you're making is that the TWP, trial work period, is basically they allow you to work, and then you kind of use that up. Then you're sort of almost in this sort of a kind of a nebulous time where you've used up your trial work period, but you're still under SGA. If you go over SGA after you've used up your trial work period months, then you get into overpay status. If you stay between trial work period and SGA, you can continue to work. You just don't have that extra buffer of using up an extra trial work period month. So the point is that you need to really know if you're working part-time after you apply or after your onset date. You need to keep really good track of the numbers of what your gross earnings are, whether they are over the trial work period number or over SGA or potentially between the two. So that's really the real issue with the trial work period. It gets a little confusing because the number for trial work period is different than the number for SGA, which never made a lot of sense to me, but that's what they did. That's what they do. So, okay. Amy Hill says, I was denied at my initial application and appealed due to a job I worked over 10 years ago. I'm 56 years old. My representative hiring an attorney to do the ALJ hearing. Okay, so now there's a lot to unpack there. You were denied on your initial application and appeal due to a job that you worked over 10 years ago. I'm not sure if I understand what that means. Why would you be denied on an initial application for a job that you worked over 10 years ago, unless you're saying that you have the skills to go back to that job? You're 56 years old, so at 55, assuming you have a physical limitation, the grid rules would kick in. So I'm not sure why they would deny you based on a job you worked at 10 years ago. Does that make any sense to you, Stephanie? It doesn't. I'm not sure if I understand what she's getting at.
Well, I think she might be saying that she was denied, and they said it's because she can do past relevant work, though, right?
Yeah, that's what I'm thinking.
Yeah. So you have to prove that your RFC, your residual functional capacities from your current. Can you hear me?
Your current RFC, but realize that they changed the rules, the look back from 15 years to 5 years. So as of, June 25th or 26th?
Well,
doesn't.
Yeah, but they didn't change it for her.
Well, I mean, I had a hearing.
Do
you think? Now, I had a hearing today where the judge says, they're going to change this by the time this decision is issued. It'll be a 5-year look back. So I'm only going to ask about the last 5 years. It's my understanding that even though that they have not formally changed it, if the decision is issued after the effective date of this change, then the 5 years would apply. So I don't know that this person, if they're being determined that they could do past relevant work, but it's more than 5 years ago, certainly as of June 25th or 26th, whatever the effective date it is, I don't remember which one it is.
22, I think.
22, June 22, that as of June 22, it should not make a difference what she did 10 years ago, correct?
Right. Okay, but I'm going to just say, she hasn't been to an ALJ hearing yet. That was on recon.
Correct. Correct.
So they have to go with the rule. I'm thinking they have to be doing the rule that exists then, and then if she appeals, she's going to get the benefit of the new rule.
Yeah, right. I think that, right. So she's done an initial, it says and appeal, and now she's, her representative, I'm guessing a non-attorney rep, has hired somebody to do the hearing. So my point is that when you go to the hearing, Amy, what you're going to find is that the judge is only going to look at the last 5 years. So what you did 10 years ago is irrelevant at the hearing. So it's going to make it easier if you get approved, because they're only going to look at the jobs in the last 5 years. So if you had a skilled job 10 years ago, but a low-end semi-skilled or an unskilled job within the last 5 years, that's really all that's going to count. So this new rule will actually benefit you, is what I'm saying.
Makes me wonder, Jonathan, if there's going to be a lot of OTRs done internally at the ALJ level when they first get all these cases in.
Yeah, OTR meaning on the record decisions, because what Stephanie's getting at is that if the state agency denied the case at initial and recon based on ability to do past relevant work, and that past relevant work was more than 5 years ago, that is no longer relevant. So you're going to see judges saying, well, now we don't know that they can do past relevant work. They meet the grid rule, and so they're going to get approved. I wouldn't expect to see a huge number of on-the-record decisions by judges. I think they're still going to want to talk to the people, but again, I think it will make it a little bit easier to win. I hope I'm wrong. I hope there are more on the records, but I don't know. I don't think so. Because realize that when you're looking at past work, the judge is going to have a vocational witness to describe what that work, how it was done, how it's described in the ancient DOT, Dictionary of Occupational Titles, as well as how it was really performed in real life. So the vocational witness testimony is not obviously available to the people at the state agency or to a judge prior to the hearing, even though they kind of know what these vocational witnesses are going to say. So I don't think we're going to see a lot of OTRs. Again, I hope I'm wrong, but I do think that vocational witness testimony will be less damaging to people going forward, is my take on this. Okay.
I agree.
Sean says, hello from Michigan. PTSD, anxiety, major depressive disorder, 70% VA, back and neck pain with degenerative disc disease and stenosis, meds for 2 years, Zoloft, waiting 10 months for the initial. I think he says he's 58 years old, waiting 10 months for initial. Let's just, let me open this up to you, because we talk a lot on this live stream and other videos about, mental health cases. What is your approach to depression, PTSD, really, which is more an anxiety disorder? What do you look for to determine whether that's you have a winning argument for PTSD?
It really depends on the vocational profile a lot. Under 50 is a whole different ballgame. It gets a little different, 50 to 55, 55 to 60, because we have those little helpful exceptions.
Helpful, in what sense, helpful exceptions?
Well, between 50 and 55, many of you have probably heard of the grids and all that, right. Good business. But the rules that if you can still do, say, a sedentary job at 52, you will not be found disabled, even if you can't do your prior work, if you can do that other work. But then if you can kick in, or let's say you can't do sedentary work, you have to be able to prove you cannot do your prior, your past work. And that can be done sometimes with a component of mental health, whether it's, I always emphasize to my guys, if you have anxiety and it is interrupting your focus and your concentration, get it followed to some way, or, in some degree or another medically, because you want that evidence to show that you might not be able to do that prior work because of, your concentration isn't such that you could transfer those skills or continue to do, if that was like a skilled job or a semi-skilled job, I think some of that can interfere. So when it's under 50, I think you have to have so much more than what we're talking about over 50.
Yeah.
Because you really have to prove that you can do no job, even an unskilled, low stress, no public, only occasional interaction with a supervisor, that kind of thing, or you will be found able to do an unskilled job at some exertional level.
Right. So I think clearly when you're over 50 and again over 55, you have a huge advantage just in general. I think two points I want to just draw attention to. One is, even though the grid rules only apply to people with physical limitations, the non-exertional impairments, the PTSD, anxiety, depression, can be used to show that you don't have the ability to transfer whatever skills you've got to some other job. And that's what the grid rules are asking about. The second point is that under age 50, you have to prove you can't do anything at all. I mean, literally a warm body job. And the example I always give would be sitting in an air-conditioned warehouse putting ink pens in a box. You can't do that because you would have too many unscheduled breaks, or you'd have to leave work earlier, you'd miss too many days, or your ability to focus and concentrate is so impaired that you simply would not be effective at work. That is a much steeper ladder to climb. The second thing is, I think the judges, when they're looking at people under 50, are looking a lot more skeptically because they are getting pressure from people above them to not deplete the Social Security Trust Fund. Now, when I'm looking at a mental health case, depression, anxiety, PTSD, I look for what I call indicia of severity. It might be an inpatient hospitalization or more, one or more recent. It might be a suicide attempt. It might be futile attempts by doctors to control the symptoms with medication and multiple medication trials with increased dosage. You look for ongoing treatment. You look for statements of support from treating psychiatrists or psychologists in the form of a functional capacity assessment. Family doctor is not going to be enough. It is a very, very high standard for people under age 50. Now, in this gentleman's case, he has neck and back pain as well as the mental health part. So, you sort of have a combined thing going on, and he is also 58. So that says to me, assuming I'm reading this correctly, that says to me that the grid rule at 202.06 in particular would apply here. And 202.06 basically says that if you're limited, even if you can do light work, but you have no transferability of skills, then you are disabled. So what do you look for what are the indicia of severity you look for, Steph, when you're looking at a psych, depression, anxiety, that type of case?
For a 58-year-old?
For anybody. Well, let's start with people under 50. What do you look for?
It's got to be so robust. You're talking about the mental health. There's no. I never want people to get the impression that there's only one way to skin that cat. You know what I mean? But it is true that if you keep going back to needing some inpatient care, that kind of indicates maybe you can't sustain even unskilled, simple stuff. But of course, there's many people who don't go to inpatient care and they cannot get out there and do a full-time job of unskilled, simple, low stress, all those that are supposed like that. So what do you do about those? Sometimes you have a really great, I would say an MD, like a psychiatrist, mental health professionals, not your family doctor necessarily, along with a really strong therapist who articulate the records in their records and are willing to share their records. And Jonathan, I don't know what you think about this, but the psychotherapy notes that the mental health profession is allowed to withhold, even if the patient wants it shared. I think those can be so valuable because they really can tell a story. They're very confidential where they're going to. And unless if they don't have that, and if the mental status exams are actually performed at each session by the whatever the provider is, if they say someone is tearful the whole time, sometimes I don't even find that to be very persuasive to ALJs. But sometimes if it shows that they're extremely irritable, very jumpy, the anxiety is they're jumping out of their skin, they're pacing, irritability. If sometimes some people have, impulsivity issues that show up in the session, or the, anger management. But a lot of these, some of them just don't record these things. They'll just say a lot of things are within normal limits, and they'll just check off that there's some anxiety, and they don't get to the, they don't really get to the severity of it. And that, I think, is a really big deterrent. And it's not the patient's fault, it's
right. Well, look, I mean, I think I've seen it, something you said before, and I've seen this too, where psychologists, either the notes, or psychiatrists, the notes are kind of illegible handwritten notes that you can't really make heads or tail of, or they're very brief, with a lot of abbreviations. That won't help you very much. Or there's some, psychologists, psychiatrists who will not release those records because they feel like if the claimant read those notes, it could be harmful to the patient, the claimant or patient. So, you got to get past that. And I've had situations where the doctor will kind of summarize, 3 years of treatment in 2 pages. And, it's not nearly as effective as sort of the contemporaneous notes, but those are some of the other issues you run into. So, yeah, I think that, psychological, disability, very, very hard. And that's why I kind of look for those external factors, the inpatient hospitalization, the suicide notes. It's more objective than just relying on the notes from the treating psychologist. But I think in this gentleman's case, who's 58, the combined effect of his physical problems as well as his mental problems, I think, would probably, would give him a favorable result, or give him a good shot at it. Normally that combination works pretty well for me. And, again, obviously every judge is going to be a little bit different, but normally if people are over 55 with something significant physically as well as mental health, that's a pretty good sign. And by the way, VA ratings don't mean anything to Social Security. Again, why 2 federal disability programs have different standards, I have no answer for that. But the VA will, they take note of it, but it's not going to be dispositive.
Yeah.
Okay. All right.
They are different.
Bryn says, I have applications still early in the process for spinal fractures and foot neuropathy. Today found I have a 3rd fracture, spinal stenosis and bulging disc. Can that be added? So what he's asking, or she, I'm not sure if Bryn is a he or she, is asking is, when they filed, they listed certain conditions, and now the cases, let's say it's been pending for 6 weeks or 8 weeks, they have additional medical problems. Can they add that to their application? Absolutely. And what they ought to do, if they're not represented at this point, they need to communicate with the adjudicator. And again, you'll get a letter from the adjudicator with typically a fax number and a name, usually first name, Sally G or something like that. And there'll be an address, but they need to put in writing that they want to add to their application that they have additional medical issues that ideally were present before, as of their onset date, but certainly have become more symptomatic now. But yeah, you could definitely add things to it. You're not stuck with what you put on there, a year ago, 6 weeks ago, 2 years ago. You can add to it through recon. And my experience has been, if you try to add something at the hearing stage that's brand new, completely different. Let's say you have you have orthopedic issues, then you want to add a mental health component at the hearing level. Some judges will say, we're going to send it back to the state agency for adjudication. So you got to be careful about that. But if you found the same thing, you can add things early on, but a little more problematic to doing it later. Stafford, can you hear me? Are you still there?
No, I just lost you. So what was your last sentence?
Okay, the last thing I said was that the question here was, can a person add medical issues to an application after it's been filed? The answer,
I did hear that.
Yes.
Okay, then you're.
Yeah. So my question.
Yeah, absolutely.
Yeah. Have you found that if somebody tries to add something at the hearing stage, that some judges will not even consider it? They'll send it back to the state agency for development before they would consider it at a hearing? Has that ever happened to you?
I have never had that happen, Jonathan, ever.
Okay. I've had.
Nope.
So and that used to happen.
And
I have had that happen. Go ahead. Sorry.
Wow.
Yeah.
Yeah, no, that's interesting. When I heard you say that, I was like, huh, never has that happened. 20
So,
years.
because really the question is, is the judge going to consider something brand new that has not been developed yet? I guess theoretically, if you provide medical evidence to the judge prior to the hearing, you could say, well, this is now part of my case. But again, some judges, and again, this is going back a number of years, but I've had judges literally, at the hearing say, we're going to stop this hearing, we're going to send this back to the state agency for development, and we'll see you in a year. Um, so, I think it maybe depends on
Wow.
the judge.
Yeah,
Yeah,
that
pretty
seems
harsh.
shocking.
Yeah, pretty
That,
harsh.
that
But
seems shocking to me because,
because go ahead.
oh, that seems shocking. I'm sorry, because we're so uneven here. That seems shocking to me because, in theory, all of our conditions change over the course of the many months between
Right.
application, initial, recon. You know what I mean? So for
Yeah.
a judge to, I mean, then you'd have to send back everything, in my opinion, everything,
Hmm.
because every body's changed. None of them, very rarely, if ever, do I see someone who has no difference in their condition. Some things improve, a lot of things get worse. So yeah, that's never happened. And, I'm up in the Northeast. I don't know if that makes a difference.
Well, I think
But even no matter what state,
yeah. Well,
West.
I think in the cases that I'm talking about, the person, had this condition and never mentioned it until the hearing, and I think it kind of upset the judge. Like, well, why am I seeing this for the first time? But I think maybe one of the factors in play here is that the delays have gotten so much longer that perhaps judges are less inclined to want to add another year to that process. I suspect that maybe it goes on their record as being a case that's not been adjudicated, and they don't want that either. So who knows? But that is definitely something that I would just say this:
Interesting.
when you apply for benefits, you want to include everything that's going on. And if something new pops up after you apply, add it as quickly as possible. Don't assume that if you get to a hearing and it's not been raised before, it's very possible the judge would hear it, as Stephanie says, but it's also possible the judge might not hear it. So it's to your benefit, and quite frankly, to your benefit, let Social Security do the heavy lifting in terms of getting the medical records. So, okay.
I would also say don't wait. Like, let's say you have a new impairment during the middle of initial. I wouldn't wait until you get a bad result and then put it in your recon appeal. I would be sending a letter or making a phone call to that adjudicator.
Yep. Yeah. No, we do that all the time. I mean, if somebody has a new doctor or they have a new condition, we'll communicate with the adjudicator and basically say, please get these records and please develop this, because that's their job, and you want them to do that. And the more you can tell them this is what's going on with my client or with the claimant, and why this is disabling. And I think that's a big part of it too. Let them know if you're doing this on your own, why this is disabling. Just to make their job a little bit easier. So, yeah, I think certainly as soon as something becomes apparent to you, make it clear to the adjudicator. All right, Johnny says, and somebody said that you're 100% disabled by the VA, that will get you to the front of the line. That is correct. I had a case today, as a matter of fact, 100% disabled veteran, and we got a hearing relatively quickly. And actually, this case was one of the rare cases where I literally didn't have to say anything. I mean, my claimant was very well spoken, very eloquent. The judge asked him a couple of questions, and he explained it very, very thoroughly. And he kept saying, "Well, I'll get to you in a second, Mr. Ginsberg." And finally, he just went to the vocational witness, asked one question, we got the grid rule, and we're done. So I literally said nothing. I love those cases. It doesn't happen a lot, but I really like those cases.
That's sweet.
Okay. Let's see. Johnny says, I'm 59 with degenerative disc disease and a hernia and had a CE. What are your chances of getting approved? Answer there is it depends. It really depends on what the medical evidence shows, and the fact that you're 59 helps. But I can't. Do you see anything else you can glean from that? I'm sure you see people asking these questions. Legitimate question, but there's no way to really know, is there? I mean, if we don't know what the MRI shows or the other objective evidence shows.
Right. What was that? 59 was, what was it, a bad back?
59 says
hernia?
degenerative disc disease and a hernia, and he just had a CE, a consultative evaluation. So, of course, we don't know what the consultative evaluation says. But having a degenerative disc disease, presumably he's had an MRI or some other objective test which will say how bad it is. Now, if the MRI comes back with mild degenerative disc disease, that's probably not going to help all that much. And the hernia, again, may or may not help him all that much. But 59 helps, but the other things, it's a matter of what the tests say, right? There's no, you don't win with the diagnosis. You don't win with the diagnosis.
Right, and those diagnostics are so important, and what they say. Stenosis, no stenosis, mild versus moderate to severe.
Right. The other thing I'll tell you, in my experience, some different radiologists read MRIs differently. I had a case a couple years ago where my client had been through a workers' compensation system, and they sent him, the workers' comp insurance company sent him to a doctor, an industrial clinic type of doctor. He had an MRI done, and the reading of the MRI was very mild limitations, nothing significant. My client's telling me, I'm in terrible pain, this is ridiculous. So I said, well, here's an MRI clinic that actually I knew the one of the owners of it, not the doctor, I knew the owners of it, and I said, let me see what he will charge you to have his radiologist read it. And I'm not going to say anything more than that. So the radiologist read the MRI, got completely different conclusions. So if you're having an MRI done at the request of an insurance company in a workers' comp or maybe a long-term disability case, don't assume that the reading of that MRI is written in stone, because different radiologists can read it differently. Have you ever had anything like that happen?
I have not.
Yeah. But
again, it's a very good story. It's a good lesson that if you can get it reinterpreted.
Yep. Yeah, because realize when you're looking at an MRI, if you've ever actually seen the films, it is not like things don't jump out at you necessarily. You've got to have a trained eye to read what it is, and there may be a little bit of motion blur, or there may be a little bit of a shadow here, and so a radiologist is going to make that interpretation. But again, some radiologists are kind of geared to minimize what they see. Others are going to be a little more open to thinking, well, this could be something more significant. So it's not always black and white. It's very much literally shades of gray in an MRI, because they're different radiologists are going to read just like a doctor might look at your lab tests and reach different conclusions depending on the doctor. So be aware of that. All right, Zippy says, would I get kicked off SSDI if I went over SGA before I received SSDI? I've been collecting SSDI for 2 years. Again, I think she'd asked this question before. If you went over SGA, they could call it trial work period months, or they could say that, your SGA was inconsistent with their finding of disability. And yeah, they could theoretically come back in and try to, revoke or disallow your disability benefits. I had one case years ago where I had a guy who was found disabled, won at the hearing, and it turns out he was doing some activities, I'll just call them volunteer activities, that were in a very controversial field. And he made some enemies doing these videos, these blog posts. And so somebody, that was not happy with his position on a particular issue turned him in. And so Social Security, sent their investigators, and they figured out that, yes, he had been doing activity at over an SGA level. They not only did they terminate his benefits, but they went after him to repay past due benefits. Pretty rare, but I think that if you did go over SGA prior to filing and that was not known to the judge, it's probably worth talking to your lawyer about, what do I need to do here? What are my options? Because that potentially could be a problem. Maybe not, but it could be.
I think he says lower down, Jonathan, if this is you with the purple Z, I never worked after being approved for SSDI. So that's helpful.
Yes. Yep. I think that's absolutely right. Absolutely right. Okay. Thank you for helping the veterans.
There's a chance of having...
Go ahead.
I was going to say, the chance of... I didn't know what he said before, if he had just worked, or was he just over TWP but not over SGA?
No, I think what Zippy said was, that she was over, I'm assuming it's a she, I don't know, she or he, let's call it they, be politically correct. Let's say they were over SGA, for, let's just come up with a scenario, for 2 years prior to the onset date. And that, those earnings did not come in, were not posted to Social Security until after the approval. So you have 2 years of over SGA earnings. That to me is a problem if it's that long. And I think that could.
And you said that was after he applied?
Well, no, it looks like she applied, got approved, and then perhaps after that point, the earnings come in. She's been on disability for 2 years, but now there's evidence to say she was over SGA for the 2 years prior to becoming approved.
Okay, so did she report that in her work history report?
Good question.
I mean, that's
yeah. That's a very good question.
That would cover her butt.
Could, very possible. And realize that if there are expenses related to the earnings that allowed her to work despite her medical issues, that could also be helpful. But yeah, I think if it was not reported in the work history form and it didn't come in until after, that's potentially a problem. But see, I think Social Security, even if you reported it on your work history form, there's no indication of the work history form what you earned. So, you may have reported it, and that's good faith there, and I think that could maybe help you if you try to ask them to waive it. But, if they still see, let's just say that the 2 years prior to, onset, she was earning $5,000 a month. That's a problem.
But that's before onset. That's
okay. Yeah, before onset. That's what she's saying here.
Yeah.
Is before onset she was over SGA. Or maybe
that's
I'm
fine.
mistaken. Yeah, right. Before, I'm saying after onset, before approval. Maybe that's the better way to put this. I misspoke.
Right.
So she's applied. She's working. Doesn't realize she's over SGA. The earnings don't come in until after the case is approved, and now 2 years later, the earnings are showing up, and Social Security say, wait a minute, those 2 years after your onset looked like they were over SGA. We got a problem. And that is a problem, I think. Even if you were.
Yeah, and it's peculiar because the work history report does ask you how much did you make and is it per hour, per week, per year. Mm-hmm. So it is on the work history report, and then how many hours a week you work. So if she said something, then they should be looking for that. And then also, I think it's if it's self-employed, then it could be a real conundrum. But if it's W-2.
Yep.
They get those, how they get those, they look at those certified earnings, and that gets reported by the employer, I think, more frequently.
But right? I've also seen situations where employers report it late, or they make an amended filing. Mm-hmm. Any number of things can happen. It's not necessarily the claimant's fault, but it does end up creating a problem. If there are earnings over SGA, I think the way to analyze this would be if there's earnings over SGA after onset, the first thing you want to do is argue that you should apply trial work period for at least the first 11 months, because that's you've got your trial work period. Beyond that,
9 months.
Well, it's 9 months, but don't you have 2 months of leeway? I think they give you another couple of months.
But you'll be in terms of them pulling the money back and you're going to be
trial work period months.
I think.
I understood it was 11, but it's technically 9, but they give you a couple of grace months. But regardless, so whether it's 9 or 11, for our purposes, is not relevant. My point is that if you use all those up and you still are over SGA, then you could be in an overpay situation.
And that's,
Yeah. Not a good place to be. Not a good place to be. Okay.
No.
Let's see here. Okay. Let's see. Hi from Tennessee. Trish says, love both your videos, so hopefully she's subscribing to both of us, which is good. Let's see here. Okay. What kind of questions can you ask? Anything about Social Security disability. If you ask me about antitrust law, I will absolutely have no idea what I'm talking about. Okay. Okay, it says an echo and a screechy sound where I'm speaking. That's just my voice. I can't tell you. Let's see if this is. Oh, you know what happened here? Let me see if my.
That's a while back too, isn't it?
Yeah, I think my microphone may
I don't know. I don't know.
That may be the problem here. Let's see here. Okay, my microphone fell off. Okay, that would be part of the reason why you hear the screechy sound. All these technical issues here. Okay, that should be a little bit better now. Okay, don't hit the red button. I don't know what the red button is, but I guess don't hit it. Okay, Nellie says, I did not receive a paper copy of the recon denial. Attorney told me, then file for a hearing in New York. Local SSA notice asked for workers' comp award and appeals. Is this standard or problematic? I would say this, workers' comp is always an issue in Social Security because workers' comp benefits tend to offset Social Security. So if you have workers' comp, you've received it during the time you said you are disabled, then you could have a problem because you would have an offset. So whenever Social Security is aware that there is somebody that has workers' comp benefits, they're going to ask for the settlement documents to see whether or not there's any kind of overlap. So that's why they're asking for it, because it does create a problem. Okay.
Yes, indeed.
Okay. Now much more clear. Yeah, that's because I put the microphone in. All right. Does a 2-time pulmonary embolism qualify? Again, it depends. I mean, a pulmonary embolism, very, very serious situation. Did it resolve? Did medications dissolve the clot? Is there any kind of permanent damage? If it's something that, puts you out of work for 4 months, not going to be enough because you have to have a condition that's going to keep you out of work for at least 12 consecutive months. Okay. All right. Patty says, I've been on SSDI for 10 years. My question is, I'm turning 65 in July. Will my SSDI go up or will I get regular Social Security? Once you're at full retirement age, I believe, you just get your regular, they just change the account, but nothing much really changes. The dollar figure pretty much stays the same. Okay. All right, Eric says, still waiting on Recon 202.06 for the win. Well, 202.06, very, very powerful grid rule. Stephanie, have you had many cases approved at the state agency level, initial or recon, using the grid rules?
I do, and I feel like, it's all relative, but I feel like presently they are more amenable to granting for our, older peers.
People on for the grid, the grids.
Yeah, I did not so much the lowers, but the hires. I feel
Ages.
like, I will say though, and I've talked about this before. A lot of reversals on recon. If it didn't happen on initial, sometimes it's an initial that took 15 months because they have all that slowness. But a lot of we're going to give it to you. We're going to give you a different onset date than you alleged.
Mm-hmm.
Very frustrating.
Yeah.
But I do feel like there's more being awarded before having to go to ALJ hearing.
Yeah, and I think what Stephanie's talking about, the onset, and this is an important point, is that Social Security at the state agency level, initial recon, they may approve somebody, but they'll change the onset date, cutting out, tens of thousands of dollars of past due benefits. So now you're faced with the question of, do I appeal the changed onset date and a victory, with the hope of getting the extra $10,000 or $20,000, or do I roll the dice? And that is a really difficult thing, because if you have no money, you're waiting, and all of a sudden they come up with, okay, we're going to approve you, but you're not going to get any past due benefits. It can be very tempting to take that. I tell my clients, look, if you are disabled enough to get approved at recon, then is the risk, I think, is somewhat manageable to to go ahead and request a hearing. Of course, you could get a judge with a very, very low approval rate. But what do you do? Do you tell people? Obviously, you give them the option. What do your clients typically do when it comes to making a decision about whether to appeal a changed onset date?
I lay down those risks.
Mm-hmm.
I do. And because I tell them what all the risks are, we actually want to go back and see why like I have one right now, awarded on recon, but wiped out 2 years of back benefits for the fellow.
Right.
And they awarded him because he did an age change. He hit 55. So they're still finding, obviously, he could do, some sort of work from a physical standpoint. But so he decided to appeal it. We did discuss that technically they can open up the whole can of worms and reverse you and this and that. But in that case, it seems so very unlikely.
Yep.
There's there's mild mental, there's physical, musculoskeletal. So now the person's like, 55 plus. So we are waiting on, we have a hearing coming up actually for it. So it's a little nerve wracking, but for people that is not a lot of back benefits, and I explain all the risks and, if there's not a lot of back benefits to be had anyway, and if we can see that there's some greatness where even though we don't agree with them, we could see why that adjudicator did that. And not necessarily because of an age change, but it could be because like there was now a better diagnostic test. We're always saying, get those diagnostics updated, so if there is something that they hung their hat on that you could tell, then I think, you might not want to appeal it.
Yep.
Particularly if there's not a lot of to you.
Right. I mean, I think it just depends on the dollars involved in it. I think it just depends on, again, like the medical. I think, look, if you're, if they were proved you at age 55, you still have a potential grid argument at age 53. But if they proved you at age 51 and you're trying to say I became disabled at 49, different calculation. I'd probably be less inclined to do that than I would be from, somebody get 55 going back to 53. So it just depends. It just depends. But I still think that if they are going to approve you at the state agency level, at a recon stage or an initial stage, and you decide to go to a hearing, how likely is a judge is going to say you're not disabled at all? I don't know that that's a huge risk, but it is a risk nonetheless. Okay. Rick says,
he's not just saying you're wrong, he's saying the SSA was wrong too.
Right. That's exactly right. Rick says, how long does a phone hearing decision take with the judge? I had my hearing February 23rd, 2024. I got 2 decisions from cases I tried 10 days ago. I got them yesterday. So it can be really quick. It can take several months. What's your experience, Steph?
Yeah, it's the gamut. It is. I have one from March that's still outstanding. It's killing me.
Yeah. I know.
So, and then I had another one. Well, that was an overpayment one, and I don't do them. That came out like a week later, but I had pretty much drafted the award.
Okay.
Try to make it super easy.
Yep, make it super easy. Well, look, I mean, judges, they don't write their own decisions. They send it to writers in a different state. And I know from talking to, I talked to a gentleman who used to be a writer in my podcast, Spencer Bishens, and he made the point, he said, sometimes I would, when he was a writer, because I would get a decision from the judge, let's say denial, and I'd listen to the record and look at the records, listen to the audio and look at the records, and I would call the judge or, write him back and argue with him. He goes, sometimes I would convince the judge to go ahead and issue an approval when, the judge's inclination was to disapprove. So that could be going on. There could be discussion back and forth between the writer and the judge. Again, I don't know how often that happens, but I guess it does happen sometimes. Or the decision gets sent to the judge and he doesn't like it or she doesn't like it and they send it back. That could happen too. Okay.
Sure. Wow.
All right.
Fascinating about that whole interaction.
Say again?
It's fascinating that they can have that interaction, the writer with the judge,
Yep.
as a writer could be, hopefully in a positive direction for the claimant.
Hopefully in a positive direction. Yeah. Well, I mean, what Spencer said was, for the most part, it was. But, he's like, look, I'm not an advocate for the claimant, but, I'm looking at this record. I'm saying to myself, there's just no reason that this case should not have been approved, and the judge's rationale doesn't make any sense. Or my argument to the judge is, you're going to get reversed, and that's not going to look good for you. So, it just depends. All right. Isaiah says, I've been on disability retirement through FERS. I applied for SSDI very soon after my approval. Would me being on disability retirement help my chances of approval with SSDI? I have MS and RP. I guess that's the vision issue. I forget the retinitis pigmentosa. But to answer your question, the FERS disability, again, I believe it's a different standard. So Social Security is not going to be bound by it, certainly. The bigger issue is that if you get FERS, they will offset your Social Security the first year where there's overlap 100%. And then I think the next year it's 60%, unlike the VA disability where you can collect both. So I think that, the underlying symptoms, if you've got MS that's symptomatic, that's going to probably play pretty well for Social Security, again, depending on how old you are. But the FERS, approval is a factor, but I don't think that's going to be determinative on Social Security. The one thing you got to be careful about is if you have an attorney for Social Security and you're awarded past due benefits, FERS is going to ask you to pay back the entire first year of benefits, including the part that was paid to your attorney. So, right now the attorney's fees are as much as $7,200. So theoretically, you get a check for, I'll pick a number, $35,000, and then FERS says we want $40,500 to be paid back. That's pretty unfair to me, but that's what they do. The second year, it's only a 60% offset, but that's one complication with FERS. Have you dealt with FERS very much, Steph?
Nope.
Yeah, it's.
It never come up.
Yep. Well, I've had it come up twice. And I had a heck of a time finding anybody who knew anything about it, but that was my conclusion. So I hope I'm wrong about that, but I think I'm right. Okay.
I feel like I've heard that whole thing about the 100% offset.
I'm sorry if you already got this, but I have my mental. By the way, I'm putting this as an earphone. The reason I'm putting it in and out of my ears is because I'm getting an echo. So there's probably a way to make this work where there's no echo, and I'll figure it out for the next time. But right now, I'm just having to do it the manual way by putting this in and out of my ear. Sorry if you already got this. I have my mental CE next week. Is it long? It is. Let's see. Is it long after that for the decision? I have excellent medical records, and I'm 58. Are my chances for approval good? My take on it is being 58 is always a helpful thing, even if it's mental, because I think there's still a bias in favor of that. As far as the time after the mental CE or the psych CE, they're going to have to get it back, which is going to take a couple of weeks. It's got to be reviewed by the Social Security person. So, it could still be a couple of months after that. If the CE is consistent with your underlying medical records, that's going to be a pretty good sign if the medical records are supportive. Again, without knowing what your medical records say or what the CE says, I can't give you an opinion about whether you're going to get approved, but I think that certainly things line up fairly attractively there if the record's good for you. Okay. Good evening. During my ALJ hearing, the vocational witness said there were no jobs in the area of my profession. The judge still denied it. Steph, do you want to explain why that would be the case?
Yeah, because the issue isn't whether there are jobs in your profession. And I think what you're talking about, maybe, correct me if I'm wrong, is that the vocational expert said you couldn't do your prior work. Mm-hmm. That's the only thing I can imagine. But then you have to go back and listen to, did the judge ask hypotheticals? Because he has to ask, are there any other jobs in the economy the hypothetical individual could do, and giving with the RFC that he already provided, and then they'll give more jobs if there are any, usually up to 3 occupations along with the numbers that exist in the economy, et cetera, et cetera. And then sometimes the judge will do another hypothetical with a slightly different RFC. So if the first hypothetical was putting you at light exertional, maybe this one would be sedentary. Maybe it would be light, but with, taking notation of maybe limitation with your fingers if you have arthritis, and would that affect those jobs? And then the vocational expert will answer that. And then at the end of the day, when there's multiple hypotheticals where there were some jobs presented to the judge's hypothetical, and then there were other hypotheticals where there was no jobs, you don't know which hypothetical the judge is going to find that you fit
Right.
in the end. And that's why when there's multiple hypotheticals, you really don't know if you prevailed or not until you get the decision.
Yeah. And look, I mean, a lot of judges nowadays, they will ask one hypothetical, usually the last one, if our hypothetical person was off task for 15% of the day, would likely miss 2 or more days of work a month, the VE, the vocational witness, is going to say there are no jobs. That doesn't mean the judge is going to adopt that as the basis for a decision. It just means he's asking that just to kind of give some parameters for a decision. But yeah, you may have 4 or 5 hypotheticals, and 3 of them, the response is there is no jobs, but 2 of them there are jobs. The judge could pick the ones where there's jobs, and that could be part of the decision. And also, when Stephanie's referring to RFC, she's referring to something called residual functional capacity. And RFC is what the judge finds. What is the residual? What's left over? What is your leftover functional capacity when you take into account these particular impairments? And that is a legal determination, not a medical one. It's a legal determination what your residual functional capacity is. So you want to, during testimony and with evidence, you want to encourage the judge to find the most restrictive RFC as possible, one that has as many limitations as possible, because logically there would be fewer jobs with the more limitations there may be. So when you hear about people talking about RFC forms, it's more accurate to call them functional capacity forms, but an RFC is a legal determination about what residual capacity you have left over after we take into account your medical issues. Okay. All right, John says, I won on grid rules for agoraphobia at age 50. That seems a little unusual to me, doesn't it? Because agoraphobia would seem to be non-exertional. Does that make sense to you?
Not so much about the grid rule. I can see winning on agoraphobia. And that when we were talking about mental health and what besides being psychiatrically admitted and all that kind of stuff, there was a case I had, person in the 50s, I can't recall if it was probably like low to mid, and it was such severe agoraphobia, it was so bad, and apparently, thank goodness, we had a really strong treating mental health professional who went to town for him, because he wouldn't even barely take phone calls. I mean, he had more than just agoraphobia. He wouldn't leave, but he also had some other things like paranoia, like thought people were like trying to, he had foil over his windows, that kind of thing. It was really major, but I think it was with that kind of agoraphobia or the other, it was a mental health finding, and I bet you agoraphobia at 50 was a mental health finding. Like, you can't do even unskilled work if you have agoraphobia because you can't leave your house.
Yep.
Right?
Yeah, I agree.
So
I don't think that's not a grid. I don't think it's a grid rules. I mean, again, I'm glad you won, but I don't know that if it was only on agoraphobia, you would win on the grid rules. All right. I have a question here. I'm on my appeals counsel stage. In your experience, do you have a case? Do you win a lot at that stage? My answer to that is, and we'll see if Stephanie has a different one, I think the appeals counsel is kind of like recon. It's many cases, a rubber stamp to the ALJ. So more often than not, you don't necessarily win at the appeals counsel. The next stage, federal court, you have a better shot at winning. So I think the appeals counsel stage is kind of I hate to call it a waste of time, but it's not nearly as productive as a federal court. What's your experience been? I
agree with that.
Yep. Okay.
I mean, I think it doesn't hurt if you can point out a few big appealable issues, but it has a low reversal rate.
Yep. Okay. Ray Scoggins, I'm not sure if I understand this question. I have spondylosis, fibromyalgia, extra bone in my back, PTSD. How can I go back and get 100% disability. Again, Social Security, not like VA, you either are disabled or you're not. So you don't get more money if you have additional problems that arise later. So if you're found disabled because of these problems, that is, you're disabled or you're not. Unlike the VA, where you might go from 40% to 60% to 70% to 80% to 100%. Doesn't work that way in Social Security. It's basically either you are or you're not, black and white. Okay. All right. Carmen makes the point that sometimes we can hardly perform our own duties. We're always on the lookout for med side effects, almost impossible to go back to work without hurting ourselves even more. Yeah, I mean, medication side effects are a big deal. I mean, I always tell my clients, that's something we definitely want to talk about in my direct examination. And I talk about it, of course, in my pre-hearing, like what are those side effects? Is it fatigue? Is it, difficulty with focus and concentration? Is it constipation, diarrhea? There's a lot of, it's poor sleep. Medication side effects can win a case. Has that been your experience as well?
I think it's super, super important. I don't think it's given the credit it deserves, actually, from the adjudicators and stuff. I think, you want to put it in there. Probably with ALJs, it's better, but I feel like they don't give it as much credit as they should.
Yeah. Well, I think that when you have significant side effects, when I find sometimes people they're so used to them that they don't really think about how this might affect them at work. And because they're used to taking a 45-minute nap twice a day, or they're used to, feeling kind of loopy and they can't, focus and concentrate. But, you got to really remember to tell the judge is looking at you saying, and really the way to think about this is every question that a judge asks you, the judge is really asking, would you be able to perform a job? So it's all, that's the focus here. They don't really care about what you do as far as housework is concerned. But if you're able to keep a house and you vacuum and you dust and you clean and you're doing all these things and you're cooking, 3 meals a day, a judge might consider, well, that's kind of roughly equivalent to what the level of functioning you might need to do at a simple entry-level job. So when you're talking about medication side effects, think about how this might affect you in a work type of environment. Because really everything in Social Security, it's really a vocational question. It's not about medical. I mean, I always try to emphasize to people, the medical is, how the medical problems impact you in a work setting, but the medical alone doesn't usually win a case. I mean, unless you're at the listing level, it's really more about the effects of the medical problems and medication side effects on your capacity, remember residual functional capacity, on your capacity to function at a job, at a simple job. Let's see. You guys are always on the point. VA will try to badger you. Don't let them see what they write in the notes. I think the point Sean is making here is that, VA, and this actually raises a bigger point, is that, when you're going to the doctor, you have to be your own advocate. How many times have you seen, and Stephanie, I'm sure you see this as well, doctors will make the initial evaluation, let's say 2 years ago, and then every visit thereafter, they just cut and paste. It's some part of some computer program. It says the same thing. Nothing has really changed. But the notes may say that something really has changed. You've got to, I tell people, read your medical notes. Use the portals, look at the notes. And if the doctor is saying something in there that's not accurate because it's just copied from, what he originally wrote 2 years ago, that could make a big difference. I mean, do you see that with medical notes?
Constantly.
Mm-hmm.
Constantly. I don't think that was the problem before there was the digital records and all that, like you said. But it is so bad. And I think I just read, and I've got to find it because I was talking about it with some other people. There was a lawsuit, I think, where the patient went after the doctor for the cut and paste business, because it completely destroy. It can insure her insurance claims, not just Social Security. I mean, it can hurt so many things. If you go to a new doctor and they're seeing this same thing and they don't, it can affect your treatment in the end. It's just, I think it's appalling. I've been venting about it. People hear me vent about it. I think it is so appalling, and it has to be addressed. I think they're kind of starting to maybe walk that way, but we'll see.
Yeah, yeah. No, and again, what we're talking about is medical records where, you go visit the doctor, let's say we're now in June of 24. You went to the doctor for the first time in April of 2022, and the doctor wrote down whatever, his or her observations were. And then every visit, every 2 months after, you go to see him every 2 months, every visit thereafter, the objective part, the physical, the history and so forth is exactly the same. It was cut and paste, exactly the same. Things may have been very different. Maybe your dosage of medication was upped. Maybe you have, you've had a surgery. Maybe something else has gone on. But those notes stay the same. And I think what Stephanie's pointing is that, this can really be very damaging to you. But if you don't read the notes, you don't see that, and you need to call your doctor on it and say, look, you're saying that this is all the same. It's not the same. Please let's have something accurate in there, because that can follow me around. That can really, really damage me, not just for Social Security, but for insurance purposes, for any number of things. Because the electronic records, there's real positives about them, but this is one of the negatives about them.
Sure. And I don't know how easy it is, Jonathan, I know everyone has I think on the patient bill of rights or something, you have the right to request that your providers change the records. And I think they even have to include, I can't tell you which law this is, but it might even be under HIPAA, but I think they have to, and I hope I'm not talking on a state level. Hopefully it's federal what I'm saying, so don't hold me to the details. But I think they have to notate that you asked for it, the change, and they either agreed or disagreed.
Yep. Well,
and then they can change it or not change it.
Yeah, and I've seen many times in records where a patient will email the doctor or write a letter. That gets in the record. So, if you have to write a letter to the doctor or send an email, that may become part of the record. And so if you're at a hearing and you want to say, look, I told the doctor that this was wrong, here it is. Exhibit 4F, page 35. This is where I told the doctor that, he did not, properly, or his assessment of my shoulder pain or whatever is out of date. So yeah, you got to be your own advocate in that regard. All right, Kendra asks a more philosophical question, I'll say. What she's asking is, do you think that Social Security, by virtue of the way they have the system set up, initial, recon, hearing, that they just hoping that people are going to get frustrated and just go away? What do you think?
I don't. No, I don't think that's the reason for those steps. But I will say, some people do give it and go back to work, and they're able to do it. So I guess there's that too. Like, they probably realize that occurs not that infrequently. But I don't think that's the reason. And I know we want to bash it, but I don't know. I don't think
bash away.
I don't think that's so. Thank you, Jonathan.
Yeah. Well, and I had a case a couple weeks ago. We just got the approval, and what I had to do was I had a client with some significant problems. She had to basically she had to go back to work. She goes, I got to feed myself. She was in a very difficult domestic situation, children, no place to live. And she's like, I had to go back to work. And she goes, I'm back at work at my old job. I'm doing a really crappy job at it. I can't remember things. I'm making a lot of mistakes. I'm getting a lot of my coworkers are covering for me. But she's like, I had no choice. So we had to go for a closed period. And, she wasn't real happy about it. But I said, look, the problem is, you went back to work over a year ago, 13 or 14 months ago. You're well over SGA. I can't really argue you're not disabled. And, we can try to say this trial work period, but at the end of the day, we had a judge, and I made a judgment call on this when we had a judge with a fairly low approval rate. I said, look, we go for the closed period, you got a shot at it, but you try to say you've got ongoing disability when you are back at work for over a year. I think that's a really, really tough call. So, that sometimes is what happens.
And it's a black and white rule. I mean, it's a black and white rule. The judge doesn't have discretion to say, I'm going to pretend it wasn't 12 months. I'm going to pretend it was 5 months in a failed work attempt. It's black and white.
That is true. That is true. Sean says, thank you for helping the veterans. Absolutely. I mean, I had, like I said, I had a case today involving a veteran, And, just listening to some of the stories she told me about, being in Iraq and the, just the danger involved in it, the physical nature of it, and just, falls and wearing these really heavy armor and rucksacks and things like that. I mean, these are folks that are putting their life on the line, literally every single day, especially, ones that are in theater, in war zones. And, we could talk a lot about what the VA is or isn't, but, there are people who have a lot of damage coming back from war, burn pits, they get, their lungs are scarred, or they're exposed to toxic fumes and gases that causes cancer. They don't get enough credit. And, unfortunately, I don't know that we do as a society a good enough job to really provide them the care that they need. So, I think I can speak for Stephanie in saying that, in the Social Security world, if we can help a veteran, get compensation, get some more money coming in, we're more than happy to do it, because we realize that they're out there for us, and our way of life and our comfortable way of life in this country, and it is comfortable by and large, is due in large part to the service of our veterans. So happy to work for veterans.
Okay.
All right. How long do I have to wait in front of the judge if I got my well, I think she's asking how long after the reconsideration denial would you have to get before a judge? I'm finding, Steph, maybe you have a different story. It's about 5 or 6 months. Not that long.
Yeah, I feel like it's stretching out now a little bit.
Okay.
So we'll see. It has been pretty short. It was the short part, and the initial and recon were going crazy long, but I feel like it might be stretching out, because I'm looking at I'm looking at some of the appeals, and I'm like, I would have thought I would have heard something by now. So I'm thinking maybe it's going 6-7 months now for me.
Yeah,
perhaps.
I think it depends also on the location. I mean, you're in Pennsylvania, near Jersey, is that right? So maybe.
Yeah, so like if I'm doing my area, it's like Wilkes-Barre. If I'm doing Jersey, it's the Newark office. Sometimes it's South Jersey. But then I have clients in every region, so it really, I guess that's why it's hard for me to pinpoint.
Yep.
I don't really go. I don't do the stats.
Got it.
I could say that.
Got it. And by the way, we haven't really talked about this, but we both obviously have websites, and we both do this kind of work. My website is ssdanswers.com, and if you go there, you can request a case evaluation. I've got a download called the Secret Swing Disability Survival Kit. So again, if you're interested in having me take a look at it, ssdanswers.com. Steph, how would somebody find you?
They can go to joydisability.com. My last name is Joy, Joy. And there's a button on the front page for free disability evaluation, and it comes right to me. So
very good. And again, I think every attorney is going to look at cases a little bit different, but when you look at them, obviously what I'm thinking certainly is this a case that I think the person could win? Because to be frank, I mean, we get paid if we win. We don't get paid if we don't win. So, your attorneys are going to look at cases where the evidence looks strong enough where it's going to be possible to win. I've had people get upset with me about that. You won't take my case. Well, you're 35 with a broken thumb, and I'm not going to take that case. So, yeah, you got to, we've got businesses to run. So, you try to, if somebody has a strong case and they're a little bit younger, may still take it. But, there's got to be a reasonable chance at winning, because otherwise, we've got overhead to deal with too. So, all right.
Right. And I would try to make the point, like, in order to stay afloat, you have got to have balance. And if you have to, depending on if you take all age groups from 18 to 64 or not, we still have to have some sort of balance. So I do take all age groups, but I have to have balance, and the stuff has to be really significant for the vocational profile it's in. So what might work for one person isn't going to necessarily work for the other person, and we kind of can glean that pretty quickly with some solid questions. But there are, I think there are some, folks who do focus, like they might not come, maybe they'll just take younger people. Maybe they are, maybe part of a legal aid or something where they're, they don't have to really worry about that component of balance.
Yep.
Like the rest of us, if we're going to keep it.
Yeah,
So.
and look, I know attorneys who take only child cases, which I think are almost a subset of this. Very difficult, for many reasons, and some different laws that apply for children. There's an SSI, obviously it's going to be SSI. There's going to be an income and resource issue, but again, some people that's what they do, and they make a business out of it, and that's hard cases. All right, here's a question about how does Social Security evaluate epilepsy related to a brain tumor, and ticket to work? I don't know much about the ticket to work. Do you have any knowledge about that? Do you deal with it very much?
I was just going to do something on this one. The way I look at it in a real nutshell is it's for when you're trying to get back to work full time. It's not for when you can't. And because it is supposed to be bringing you back to work full time where you get off of SSD. So it's got a whole goal kind of intertwined with it, I think. So I think it's great for people who are going that way, particularly for young people, perhaps. Mm-hmm. But I don't know that it's necessarily something that some people are going to be wanting to do, because you're expected to be trying to get back into SGA. You're trying to get back into SGA and earn a substantial gainful activity living, so that you're no longer on SSD. That's the whole point, to help you get off of it. So if you're 59 years old and you've got some major problems that disable you, are you really going to be trying to add that difficulty to your life necessarily by trying it? Because once you're off, you've got to, that would require presumably a expedited reinstatement if you suddenly couldn't do it again. And so I think it's not for everybody.
Yep.
But it's certainly good for some.
My understanding is the ticket to work has really not been all that successful as a program in general. Not a lot of people really take advantage of it.
I'm not surprised. I mean,
yep.
they're probably concerned. Plus, I don't know how many people actually. I mean, some people who have an injury where it's a surgery that's going to get you back and you're getting back to your lighter sedentary job, But for everybody else, I don't know that that's, as age even gets to us, we degenerate. I mean, we know. Right?
Oh, I mean, look.
So
look at me. I can barely stand here, so I know. All right. Here's a question about epilepsy, and this is again kind of related. The person is asking about the ticket to work, but this kind of brought to mind another question. What is your take, Steph, on seizure cases, epilepsy, seizure, things like that? Even seizures that are not necessarily epileptic, they're sort of idiopathic seizures. Have you had much luck with those cases?
I will say I haven't had great luck with pseudo seizures. Mm-hmm. Unless there's if that's all you have, that's a psychosomatically caused seizure. You do have the seizures, is my understanding. It's just that it's caused from, a fragile state of mind, and I really feel for seizures generally, you probably have to meet a listing.
Yep, I would agree.
If that's your own impairment.
Yep.
I think it's listing or nothing.
Yeah, I think, my experience with seizures, the problem has been that, first of all, people are sometimes can be a little bit vague when they talk about, I had a seizure. And, there's one thing when you have a grand mal seizure, again, person is on the floor, eyes rolled back in the head, foaming at the mouth, that type of thing, as opposed to, I'm sitting here and I'm just staring straight ahead and nothing is happening. And all of a sudden I snap out of it. That's not the same level of seizure. And I think the other thing is that, seizures, typically there's, tests they can do, brain scans, whatever, to monitor the brain activity to identify that. You almost need to have, a documented seizure, activity with brain scans that are continue to occur despite medication or any other procedures. Because if otherwise, it's comes very subjective. And I find that judges just are not that, open to finding that somebody has a seizure disorder unless there's real clear proof of frequency and duration and after effects of it, but that they're documented. So it's not like I had a seizure. You got to prove that you're really having them uncontrolled.
Yeah, I agree. And again, the listings, I had talked about the listings a while back, and honestly, I'd have to reread them every time I would have an epilepsy.
Mm-hmm.
It's a little in the weeds about how often and when the third month starts and when this, and different kinds of seizures too. They treat them differently. So it's a little complicated, and I think listing is probably the way you're going to have to go.
Yep. All right. Cheesy Man 2093 says, "Yo, I'm a Giant fan. What's up?" Well, if you're a Giant fan, I have my sympathy to you because the Giants are going nowhere this year. Just telling you. Just my opinion. All right. But, hope springs eternal. They haven't lost a game yet this year so far. Okay. If I'm forced to retire from the police department at age 42 after 18 years of working for them because of lumbar and cervical radiculopathy, I've had a fusion and symptoms are still present. Okay. You're 42 years old, but you've got some significant issues. What's your take on this one, Steph?
Well, you're going to have to prove that you can't do any of the bucket of 12,000 occupations, including, and this really ticks people off, and I'm so sorry about it, the minimum wage, unskilled, sedentary. You have to go down the line. This is for your under 50s and 42. Unfortunately, and by the way, thank you for your service as a first responder. So I think you're going to have to show either a strong mental component with that, maybe, and a serious physical component, because you have to be able to get yourself out of sedentary jobs or sit-stand option jobs. How about those, Jonathan?
Mm-hmm.
Sit-stand option.
Yep, sit-stand option.
That
means, by the way, that you have a job, where you can sit or stand, so you can do it, sitting or standing, or you can, up and down, as long as you're not having to walk around and take time off. But you can, as long as you can stay at the work site.
Yeah, the work lets you do that. It lets you do it here or sitting down, and they try to nail people on that.
Yep. And I think
I think it's going to be a.
Go ahead. I'm sorry.
I was just saying about the 42-year-old officer. I think it won't be a problem probably not being able to do prior work.
Mm-hmm.
But that doesn't help you so much until you're 50.
Yeah. Well, the other thing here is he's 42. He's at 18 years, which is a lot. I think long work service does make a difference. He's got radiculopathy. Again, he's got a fusion. Does the MRI show or CT scan show that there is a problem with the fusion? Is he on significant pain medications? Does he have what they call failed back, where the back problem is so severe that there's really nothing that can be done to allow him to function? Are there any skills that he's learned from his work as a police officer that could, he could serve as, private security, or he could be dispatcher or something like that. So those are the things you got to get past. But the big picture is, you're used to doing, and a lot of people say this to me, only thing I know is being a truck driver, being a police officer, being a teacher, being a nurse. That's not Social Security's problem. I hate to put it that way. They're saying, I don't, the fact that you've been a police officer, and that you can't imagine yourself sitting in a warehouse putting ink pens in a box. If you can put the ink pens in the box, you're not disabled. So, that's the issue. You got to get past that. And at 42, you got to have a lot. And again, not that it's impossible, but there needs to be objective evidence of something really significant going on with that neck and back. I'm thinking pain medications and really, support from a doctor who's willing to do a functional capacity evaluation to really say that there's nothing you could do. And again, if there's other things going on too, some depression, some anxiety, some PTSD, that could add on to it. So uphill battle, not impossible, but definitely an uphill battle.
One thing I would say when you have like the bodily, like musculoskeletal and all that, let's face it, when you have failed surgery and the pain is egregious, whether you're sitting or standing, and when you're lying down. But a lot of, when it's really, really bad, a lot of people have to go lie in a recliner or ice, heat, lie down vertical, multiple hours during like a regular day. And they're at home now because they're not working. And that's what they do with ice. And if that can be proven, and if the medical records show this failed problem, through MRIs and all these other things, maybe there's scar tissue, where they sort of, if you can prove, and if your doctor maybe goes to town on it in records saying it's so bad he has to, lie down most of the day and put his feet up, he has to ice. I tell him he should ice it every 2 hours. You probably won't get a doctor that good that will say that. But if you can prove that you have to be horizontal or the recliner, because you have to, and that's very, very hard to prove. It's because it's something that's privately done at home. That's why it's so hard to prove. But the best way, if you can do it, is by talking about that. If that's the case, if that's the way your days go, that's really what I feel like you need at a young age for the physical capacity to say, no, less than sedentary, can't even do sedentary work.
Yeah. Look, and I think also keep a pain journal. Not that that's determinative, but that would at least show some evidence of the long extent of your pain. And if you can get third-party statements, somebody who observes you, maybe a neighbor, or it could be a relative, ideally a former coworker, who can talk about, what that person observed about your pain behavior, that can help too. But again, big picture here, we're coming back to is at 42, uphill battle. You're going to have to have a lot of evidence at 42 that you wouldn't need to have at 55. Okay. Let's see. Okay, this person says, how long after a termination can you start over from scratch? I'm guessing you could start over, whatever date they determine that your disability came to an end, you can ask for disability beginning again the day after that. But realize if you were terminated for medical improvement, you're going to need to show something has changed. So, you can't simply just say, well, I'm just going to try again, and they're not going to go back to the original date of your disability. It's going to be as of the date of termination. And so, something significant has changed, which is why when somebody loses at a hearing, or denied at a hearing, I hate to put the word lose because you've been denied at a hearing, and you want us to just file a new application, and you do it the day after or the week after you got your denial notice, you're going to probably get the same result because you got to show something significant has changed. Wouldn't you agree?
Yes, and they're gonna give some respect to that ALJ's decision, and specifically that, like, he found that you are not disabled, from the time of his decision going backwards, based on those medical realities. So you need to kind of show a different medical reality. I would think it can help people to, same with true when you stop work sometimes, don't necessarily file the next day. Get your ducks in a row, get that treatment going for the next few months, so that there's something to hang a hat on your file.
Got it.
A start.
Got it.
Anyway.
Okay. All right, so let's see. I was turned down once, now I have a lawyer. My case is expedited. How long does it take to get from court to there? I'm not sure if I understand that question. I have a lawyer and my case is expedited. Why would it be expedited is the question. Don't really know. Huh, okay.
Which person is this?
This is LaDonna Taylor. Does that make any sense to you?
I'm scrolling.
Interesting. Okay, so we have, Greg Brinkley is here. He's the Disability Yoda. And Greg says, Ticket to Work focuses on people who are striving to get back in the world of work and need the work incentives provided to help them get there in a nutshell. Maybe, Greg, I'm going to have you on one of these weeks so you can talk about some of these programs. Greg used to work for Social Security in many, many capacities. We did an interview on my podcast at ssdradio.com, and he has a lot of knowledge about what goes on in Social Security, kind of behind the scenes, and sort of the processing of claims and some of these programs that, attorneys like Stephanie and myself, we are, focused on getting people on disability. When you get to things like ticket to work, and other things like that, or even terminations or investigations, we don't really deal with that because, again, we're trying to get people on disability. Some of the things that happen thereafter, Social Security will deal with those, but we're not necessarily involved in that. So Greg has a lot of insight about that, and I'll get him on. I know he's got his own live stream, if I'm not mistaken. I think, and you go to look up Disability Yoda, YODAA. Go to Disability Yoda on YouTube or on online, and you can track Greg's live stream down and his videos down. Got some really good stuff out there. So Greg, thanks for tuning in, and I'll get you on here one of these days. We're trying to figure out all the technology here, so we're working at it. Okay. All right, so Anna says, I'm 25 years old, female. I'm a sex trafficking survivor since 2021. I was held hostage in the Virgin Islands, sexually assaulted. Again, that is a level of mental health impairment that, might move the meter for Social Security, because I can't imagine, what you've gone through. And, I don't know what kind of treatment you've had, but clearly, the trauma that you've gone through would certainly be something where PTSD might very well be applicable here. So, I think that's one of these cases that even though you are younger, you might very well have a claim. But again, the story you've given me here, obviously just indicated on the comment section, a judge isn't going to not going to say just believe that. There's got to be some evidence, whether there is police reports, whether there is psychiatrists or psychologists who kind of report what you're going through kind of in real time. And this kind of is a bigger point, is that judges, and they've said to me, I believe your client. I don't doubt what he's gone through, but if I don't have evidence, I can't approve based on what somebody tells me. So the story that Anna is describing here is horrific, but Social Security is going to say, show me the evidence. Agree?
I do agree. So
Yeah.
the mental health evidence has to be really significant.
Yep.
Because if you're saying you're significantly mentally limited, maybe that fear, phobias, that kind of thing, fear of people. It could be fear of leaving the house, but you have to have all that mental proof, and it's got to be somewhat of a duration.
Mm-hmm.
And then I don't think it would hurt to get all that past proof, even though that's not the period you're going to be proving. It could add a little fodder to the.
Yeah.
To say it, everybody's human, right? So
Yep.
if a judge sees that combined with your strong mental health treatment records, I think that can be significant if you have that proof of the past.
Yeah, look,
And that kind of goes back, John.
Yeah, no, I'm saying for mental health cases, I've used school records, from somebody who was in school 35 years ago, because it shows the long duration of the problem. So absolutely.
You can get them.
Okay.
Sure. And it also goes back to this is where you would want that psychotherapist to release the psychotherapy notes. I've never had somebody not release them, Jonathan, because they thought they would be dangerous for the person. I know that's a legal avenue, but no, never. Not even like severe schizophrenia cases. But it's always just been like, oh, we're not allowed to send out our psychotherapy records, and they're under the impression that they're not allowed under the law, which is false. Mm-hmm. They have the discretion for that. Under HIPAA anyway, but so when they don't forward those, I think that would be not good for the patient in that kind of instance with the past of the human trafficking and the trauma.
Absolutely. Well, Anna makes a couple other comments. One is she just says, I was admitted in and out of mental health institutions for bouts of PTSD, anxiety, and depression. And again, that's one of the indicia of severity that I think, is certainly applicable, that would certainly show
Sure.
a pretty significant problem. And, do you talk to your doctor about helping you with the SSI application process? I don't know that the doctor is going to be helping you with the SSDI or SSI application. Really, that's more of what a lawyer would do. But certainly, if you ask your doctor, would that doctor help you by documenting or filling out a form that really documents the level of impairment you've got? Having the doctor in your corner can really make a big difference. So I think that's what I would tell you to do. All right. So Trish says, should I file my appeal? I'm guessing the reconsideration. Immediately or wait till you find a lawyer if the denial was dated June 6th. I mean, you can file your reconsideration appeal on your own. You don't have to have a lawyer. It's actually one of the more simple forms to do. Many people choose to have a lawyer do it, and probably, if you're going to need a lawyer if you get to a hearing. So, if you got your denial notice June 6th, and actually, by the way, you received it June 6th, look at the date. I talked to a person today who got the denial notice literally almost 4 weeks after it was the date on it. So look at the date on the actual notice. But assuming you have, let's say 50 days remaining, I would say probably try to get a lawyer lined up and have the lawyer do the reconsideration appeal. If you've got, 5 or 10 days, get the appeal done, then get a lawyer as quickly as you possibly can. So you don't have to have a lawyer, but certainly, for the recon appeal. But if you're going to, if you think this is a case that's likely to go to a hearing, probably wouldn't be a bad idea to do that. But yeah, sooner rather than later. 60 days, it's interesting. In most legal matters, you have, 60 days is a very short period of time for many legal things. I know most lawsuits, you have 30 days to respond or whatever, but when you're doing civil discovery work, for example, you might have a period of months, and a lot of areas of law you have months. 60 days is not a lot of time. So if you don't have a lawyer, you think you want one, get on that right away. Call different people, talk to them, get a sense. You may find certain cases you're going to have a hard time finding a lawyer. Some, again, if you're younger, there are many lawyers who won't really talk to you. Or, if you've got a condition that is more subjective, you're going to have a more difficult time. If you're SSI only, you're going to have a really difficult time. So, I'd say get on that as soon as you possibly can. Okay. Okay. I'm not sure the question. It says cancer the day you couldn't work anymore. So I'm thinking what you're asking is, would your onset date be the day you were diagnosed with cancer? Not necessarily. I think it's, if you stopped working because of symptoms before then, the day you stopped working or the day you either stopped working or the day you stopped being able to do your work at the, at a level that is, consistent with what a competitive employer would expect. If you were getting a lot of, let's say your coworkers were, donating a lot of leave to you, you were doing things that, you otherwise wouldn't, you were getting a lot of help, stuff like that, then I think that you could possibly go for a date before you actually stopped working and argue that the last 3 or 4 weeks was an unsuccessful work attempt or, something like that. But, generally speaking, they're going to look at the day you stopped working at a workman-like or an SGA level, or it could be the day of a diagnosis if it was after that. What do you tell people, Stephanie, when it comes to choosing an onset date?
Yeah, it's complicated actually. I think a lot of errors are made in it because you also have to look at failed work attempts under SDA. It could be for cancer in particular. Yeah, I guess your starting point would be when you went under SGA.
Yep.
And you're treating.
Yeah.
Those symptoms are going to be noted in the record, like, but there is no book on that. That really is I think a factual case by case, very fact specific.
Yep. Judgment call. Well, the thing is, what I find people sometimes make mistakes would be is that let's say that they stop working in, February, February 15th, but they remain on the payroll because they've got accrued leave. And then they're finally separated from their employment in June. Well, the onset date is February. They may still be getting paid, but they last showed up at work in February. And that's what the relevant date is. Or they stopped work at their longtime job back in October of 23. They've tried 3 or 4 different things that have lasted a couple of weeks each. And now we're in June. Okay, I can't work anymore. Your onset date's going to be back in October when you stopped working at the SGA level. So, don't assume that, and I've had people tell me that Social Security tells them otherwise. They might tell you the wrong thing. I've had people tell me you have to use your onset date as the date of your application. That is wrong. It's the day you stop being able to do the work at an SGA level, or a level that would be consistent with what an employer would expect in a competitive work environment, is really the way to look at it. All right.
Yeah, I agree. I think some people will confuse the SSI fact that they're not going to look backwards before the date of application to find an onset date, but don't confuse that with SSDI, which of course you can go back.
Yep. And a lot of people think for some reason you can only get 1 year past due benefits prior to the date of the case of being approved. That is absolutely not correct. You can go back a year from your application. And again, the onset date's got to fit that, but you can sometimes get. Sometimes we have cases where we'll get, 2, 3, 4 years of past due benefits. Tens of thousands of dollars. It's not just 1 year. It's 1 year prior to the date of applications you're eligible for benefits, not 1 year prior to the date of the decision.
Right.
Okay, couple more questions.
And you always try to allege the oldest date you can.
Absolutely.
Legitimate.
Okay.
Yeah.
We're getting a little short on time here, so let's just go through some of these quick. Stephanie, tell me, acupuncture, what's your take on that?
Have not found it to be particularly helpful in cases, although I will say I don't have a lot of clients that do it. So that could just be a numbers game.
Yeah, well, acupuncture is not considered, an acupuncturist is not considered to be an acceptable medical source by Social Security. So a diagnostic, evaluation by an acupuncturist is not going to carry any weight. The conclusions that the acupuncture practitioner makes about, future treatment is not going to carry any weight. You need to have a medical doctor. Social Security is very much about, Western medical, traditional medical treatment. Constitutional immunity says, I have 5 failed spine surgeries, and the doctors tell me no more they can do. Sounds to me like you have failed back syndrome. And if you're insured, and you have limitations and you're on pain medication, you're spending most of your day in a recliner, that sounds like a pretty good argument. Agree?
Yeah, 5 failed surgeries is huge. 5 surgeries, period.
Yep.
If it's in the back, on the spine, that's a lot. That's a lot.
Angela asked about fibromyalgia. That's another issue that pops up a lot. How do you look at fibromyalgia cases, Stephanie? What would you expect to see for a winning fibro case?
Well, I'm looking at the fact that Angela said she has arthritis in her knees. And that gives great additional fodder for her case versus just fibromyalgia. Although, at 62, and again, it depends on the rest of the vocational profile for sure. If your goal is to get to light or below, the fibromyalgia could be doing that. You know what I'm saying? Like, it's not like you have to prove you can't do a sit-down job necessarily, depending on our profile.
Have you found, though, that fibro cases are more difficult to win than they used to be?
Whenever I have someone who calls about fibromyalgia, we talk about all the other impairments they have, because those are the ones that are going to be more persuasive. Fibromyalgia is accepted as a medical impairment by the SSA, thankfully, but I still find that there's a lot of lack of consideration for it by the SSA adjudicators and ALJs.
Well,
But if you
anything.
have, so I always look to the other.
Go ahead.
I was just gonna say, you know, all the other impairments, big and small, are what you're gonna want to make sure you have in addition to that fibro.
I agree.
You know, if you have arthritis, there is. I don't even know if I've ever had a case that was just fibro.
Yeah, I have. It's really hard because, you know, fibromyalgia is sort of a diagnosis of exclusion. And, you know, first of all, there was a period of time when you see family doctors diagnosing it. That didn't go anywhere. You get a rheumatologist diagnosing it and referring to the criteria from the American College of Rheumatology. You got a chance. But again, it's a really, really tough condition to win because you can't, there's no way to really image it. I mean, it's just very much about what you report to your doctor and medications and things like that. It's physical pain, but there's not really any kind of nexus between the pain and what's going on in your body, that you can see, and that's the big issue with it.
The objective diagnostic.
Yep. All right, that Tell It All Now says, what if you haven't worked in 5 out of the last 10, but you have 40 work credits? I'm thinking that means you're eligible for Social Security retirement when you hit 62 or 65, but you wouldn't be eligible for disability if you don't have enough credits recently. Is that the way you read that?
I would add one little caveat. Yeah, I would. The retirement is good, right?
Mm-hmm.
That doesn't go away. There's no reason to test, guys. But what if he hasn't worked in 6 years? Wait, I haven't worked in. If that's what he's saying,
Mm-hmm.
I haven't worked in 5 out of the past 10 years. Does he mean is lacking 5 calendar years?
I'm reading this that this person doesn't have 20 credits.
Yeah.
In the last
Let's just
5 to
assume
10
that's
years.
it.
Yeah.
As of today. But what if, Mr. Tell It All Now, did you become disabled 3 years ago?
Mm-hmm.
So then stem your prior 10 years prior to that.
Mm-hmm.
You see what I'm saying? Like, it depends when your alleged onset's going to be. It's not, if your alleged onset date isn't today, that wouldn't necessarily, you wouldn't be necessarily looking at today and backwards 10 years. You need to go from back year, right, Jonathan? From the from the alleged onset date to the prior 10 years.
Well, and sometimes you find you get yourself in a situation where the date last insured, your credits ran out 2 years ago, 3 years ago. And, you know, in my experience, 2 or 3 years, let's say the date last insured, that's when the SSDI credits ran out in, we're in 24, let's say in 2022. You know, that's not always a huge problem. When you start to get beyond 2.5 years, that's when it becomes more of a problem. Trying to prove somebody's disabled 4 years ago, you know, is much more difficult because the medical records just a lot of times don't really go there. Now, sometimes they do, but I think that, you know, it's one thing if the date last insured is December 2023, I'm in, we're June of 24, not a huge problem. December of 22, it starts to be more of a problem. December of 21, that's a problem, I think. What's your take on that, Steph?
Yeah, and also the fact that you are breathing down the neck of your DLI if you're not doing even part-time under SGA or even under TWP, even better, work to keep your credits coming in. You're about to have your window closed, and so all the evidence that they're developing today that's still in their window, pretty soon, none of the evidence that, it's not that the new medical treatment after the DLI isn't going to be important to something, but it's not going to be able to be important to the first question that you have to pass is, were you disabled before your DLI? And that that is always concerning. Like when you leave yourself one bite at the apple, you got one chance. Now, if you filed closer in time to when you stopped working, you could have 2, 3 potentially bites at the apple, right?
Okay.
And then you get your evidence better and better and better.
All right, a couple of people have asked about Stephanie, and she can tell you as well as I, but it's Stephanie Joy, Joy, and her website is joydisability.com. So it is, joy like happy, joydisability.com, and she is a disability attorney in Stroudsburg, Pennsylvania.
Yeah. You have trouble saying that, huh? East Stroudsburg.
East Stroudsburg.
Area.
Okay.
Really all the regions across the country, but that's where I am.
Yeah, most of us, by the way, that do this kind of work now, and you probably know this, but now Social Security disability hearings are done remotely by phone or video, so it really doesn't matter where you are, where the attorney is. It's not done. You're not going live to a hearing office. In fact, now I'm starting to see more and more judges, will be in a different state. So let's say you live in Florida, they'll get a judge in Mississippi to hear the case because the judge has some, availability. I'm in Atlanta or Stephanie's in Pennsylvania, and my client could be, in Hawaii. It doesn't. I had a case. My client was in Vietnam. It doesn't matter. So most attorneys now are pretty much able to do this from any place. So that's for the claimants. That's a really good thing. You have your choice of a lot more attorneys. You're not just limited, especially if you're in a small town. Let's say in Minnesota, you're not limited to trying to find. There's only one attorney who does it, part time. This way, you can find people that do nothing but disability, no matter where they live. So that's a good thing. Okay. We got time for one more question. And this is a good one from Angie Vasquez. She says, can you give an example of how you would start a hearing when the judge says, why are we here? What do we say? So we have a judge saying to Angie or some other claimant, tell me why you feel you're disabled. Stephanie, how do you advise your clients to answer that question?
Oh gosh, and hopefully we prepared this in advance in a certain way. Yeah. I think people get so nervous and they say, they seem to hone in on the things that don't make it, that just aren't the strong points. So, and it really depends on what your impairment is. So speak to your representative about it. But you want to get to the reason why you can't, and again, it's going to depend on your case, vocational profile and everything else, which your rep can explain to you. But like, if your case relies on the fact that you can't do a sedentary job even, maybe because you have to do that reclining we were talking about, elevating your legs for edema and swelling or whatever, 3 out of 8 hours. Or if you have the agoraphobia we were talking before, and there are some days you can't leave your house. So you want to hone in on the things that is relevant to your case. I do see people jump on the vagaries too, like, Judge, I'm in a lot of pain. It's real vague. I'm in a lot of pain and I just can't do it. Or they might say I can't keep up. That's implying that they're slower. Maybe they couldn't keep pace with their old job. A lot of times they focus on their old job, but you kind of have to have more to it than that. But on the same token, really what you say, your representative is going to be directing you to bring out everything that you guys discuss that's important. Yep. So if you don't say it right, you don't get anything out, I don't think you should be upset either. The judge knows you're nervous as anything, and I think it's all correctable. Unless you say something really weird like, well, I can only jog 10 miles now. I used to jog 20 in the morning.
Yeah.
So,
I think motorcycle riding is not a good thing. I've had a few people mention that. That doesn't usually go over very well. My comment to this would be that when you're talking about, the limitations, remember, as Stephanie said, this is about your capacity to do any kind of job at all, not just past work, any kind of job. You want to be very, very specific. Stay away from not very much, not very far. I can't do much at all, any length of time, not much. That doesn't help you. You want to be really, really specific, and you want to focus on those things that would impact you at a job. The medication side effects, I can't focus and concentrate, or I've got to lie down 2 or 3 times a day. But at the same time, you always want to go with the idea, I hate the idea I'm filing for disability. This is the last thing I wanted to do at my age. I sort of had planned to be working till full retirement age. I missed the socialization at work. And if I get better, I'd go back to work in a minute. So right now the problems would be dependability and reliability, and specifically my back pain causes this or my knee pain causes that. But I'm not giving up, Judge. But this is why right now, and since my onset date, I'm not able to work. And that's what I tell people. And look, as Stephanie said, in a pre-hearing call, you really should go over that with your lawyer so that you have, a clear, and take notes. Again, you can write it down. Don't read a statement, but kind of take bullet points. You want to make sure you hit on these highlights and you talk about all the areas of impairment and the practical effect. And, when people say, I can't really explain it, well, that's not good enough. You got to explain it. This is your hearing. So, I think that's something that really a good attorney will work with you on to get you to the point where you can explain it in a rational, logical way without sounding like you're invested in the idea of being disabled. That you're doing this reluctantly, but realistically, this is where you're at. And that's what I tell people as far as how do you answer that question, why can't you work? So that's my take. Okay.
It's funny when they ask it. They don't all ask it, but it's funny because you're like, right.
Absolutely. Okay. And Emily, my pleasure. See that little note. Okay. Well, I think at this point we're going to go ahead. We've been at this for a couple hours. I'm sorry for the technical glitches at the beginning. I'm working on that. Like I said, we've got the equipment, and the problem, just so you know, is that there's a delay between what you're seeing on YouTube and the stream and what I'm seeing and I'm hearing. So I'm trying to figure out how to kind of get past that. But I think once we got past the initial part, we did okay. So anyway, just to reiterate, I'm Jonathan Ginsberg. If you want to reach me, go to ssdanswers.com. Stephanie Joy was kind enough to join me tonight. Her name again, Stephanie Joy, Joy Disability, JOY Disability.com. We both do cases, nationally. And again, this is a nice area of practice where, attorneys typically cooperate with one another. There's a lot of cases out there, obviously, but there's a lot of cooperation. And Stephanie, has been really kind of at the forefront of creating this LinkedIn group to really help attorneys really talk about the issues. And I appreciate that, certainly. And, it's a good area of practice because it's not so cutthroat as you might find some other places. So anyway, thanks, Stephanie, for your time.
Great.
And we'll talk soon.
You too. Talk to you later. Bye, everybody.
Bye-bye. Okay, so I'm going to end the live stream now. And I hope everybody has a good evening and a great weekend.